All right. All right then.
Okay.
Morning. I'm David Barish, Chairman of the Pennsylvania Gaming Control Board, and if you haven't already, please put your electronic equipment on silent, please. With us today, Jen Langen, representing Joe Torcella, State Treasurer, Kristen Heidingsfelder, representing Revenue Secretary Dan Hassel. Apparently our ag representatives are busy with something called a farm show this morning.
Cow milking.
Is that?
Cow milking.
Cow milking contest this morning. Quorum of the board being present, we'll call the proceedings to order. First order of business, pledge allegiance. Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before we get started, we have a few presentations of 10-year service awards. Kevin?
Good morning, Chairman Barish, members of the board. With the assistance of Joe Bott from our Office of Human Resources, I have the pleasure once again to officiate on the recognition of 2 employees of the Pennsylvania Gaming Control Board who have reached a very significant milestone, the milestone of continuous and loyal service to the Pennsylvania Gaming Control Board for 10 years. So Vicki and Michael join 158 other employees, other colleagues who have also attained that significant milestone. So I'm pleased to report that of our 300 complement agency, 53% of our employees have reached a 10-year service goal, and we're very proud of that as an agency. So Joe, come on over. First, please stand up. Would like to recognize Vicki Schreiner. Vicki began her employment with the Gaming Control Board on November the 3rd of 2008 as a clerical support specialist for the Bureau of Administration. Since May of 2016, Vicki has held the position of licensing analyst for the Bureau of Licensing. Vicki, thank you very much and congratulations. And our second honoree is Michael Rowland. Michael was hired for the Gaming Control Board on December the 6th of 2008 as an Assistant Chief Enforcement Counsel for the Office of Enforcement Counsel. Today, Michael serves as a Senior Counsel for the Office of Enforcement Counsel. Michael, congratulations and thank you for your service. Thank you very much. Thank you, Chairman.
Thank you. By way of announcements, the board held an executive session yesterday, Tuesday, January 8th, to discuss personnel matters and to conduct quasi-judicial deliberations relating to matters that are going to be considered by the board today. First order of business this morning will be an oral argument regarding Woodlands Fayette's petition to surrender a license of Joseph A. Hardy III. Can we please have representatives come forward on that matter? Before we get started, I just ask counsel to please stand and spell your name for the court. Not stand. Spell your name for the court reporter, please.
Certainly. Michael Fabius of the law firm Ballard Spahr. Last name is spelled F as in Frank, A, B as in boy, I-U-S as in Sam.
Okay. You can begin.
Thank you, Chairman, Commissioners. Good morning. My name is, as I said, Michael Fabius, here representing Woodlands Fayette, LLC. First, I'd like to thank the board staff and the Office of Enforcement Counsel in particular for its diligence reviewing this matter. We have before you a set of stipulations to provide a definitive record, leaving for your consideration a question of statutory interpretation. particularly when it comes to who does or does not have an interest in the casino licensee. Transparency is the standard, and I'm glad there's quite literally no need for a contested hearing. The facts are what the facts are. Woodlands Fayette LLC, as you see in the stipulations, is ultimately owned by the 2001 Irrevocable Trust of Margaret H. McGurko. That trust, as the name implies, was established in 2001 as part of Mr. Hardy's estate planning, and the ownership in the resort was consolidated and transferred to that trust in 2001. And as part of a succession plan completed in 2003, Mr. Hardy transferred full control of the resort to his daughter, Ms. McGurko. So since 2003, Mr. Hardy has had no ownership or control of the resort. It's really truly been the Margaret H. McGurko show. She controls the trust through the, she controls the resort and the casino licensee through the 2001 trust, for which she is the sole trustee, sole beneficiary, and the subsequent grantor. I say subsequent grantor because the nature of this 2001 trust, as the name implies, it's an irrevocable trust with respect to Mr. Hardy, but it's also a grantor trust with respect to Ms. McGurko. The difference between a grantor trust and an irrevocable trust is at the core of this issue. A grantor trust is one in which the grantor retains certain rights and authority over the assets in the trust, including a right of substitution. And a grantor trust remains part of the taxable estate of the grantor. An irrevocable trust, on the flip side, is a separate taxable entity. Gifts made, contributions made to an irrevocable trust are, as the name implies, irrevocable. And the grantor explicitly disclaims, renounces, and relinquishes any rights to the assets in the trust. They are quite literally, the grantor and an irrevocable trust, two separate legal persons, taxable persons. This trust, it has two provisions. They're referenced in the stipulations establishing the nature of the trust as an irrevocable trust. Article 2, Section 4 provides that the grantor, quote, disclaims, renounces, relinquishes any of the powers with respect to the trust or its administration or any interest in the income or corpus of the trust, which could cause this trust to be treated as a grantor trust. Article 8, Section 1, if you forgive me for reading the quote, the grantor further hereby renounces and disclaims any reservation of interest herein or in the trust assets, regardless of how remote or how arising. That brings us to the question of, under Section 1325D, how long Mr. Hardy must maintain a principal license for the trust to maintain its eligibility for a principal license. Section 1325D provides certain eligibility rules, one of which it requires that the grantor qualify for and is granted a license as a principal. Plainly stated, Mr. Hardy has qualified for, fully participated in the licensing process, been found suitable by this board, and has been licensed as a principal. The question that we submit in this petition is how long must he maintain that license? There are three possible interpretations in my view. One, in perpetuity. Practically speaking, a trust is designed to outlive its grantor. There will undeniably be a time when the trust cannot bring Mr. Hardy forward for licensure. I respectfully submit that can't possibly be the intended interpretation by the General Assembly in Section 1922 of the Statutory Construction Act. Spells out that the General Assembly doesn't intend a result that is impossible of execution. Possible interpretation 2 is until he dies. He must maintain his license until he dies. Respectfully, we respectfully submit that should not be expected of him or the trust. Whether or not Mr. Hardy is alive or deceased should not, in our view, be the licensable standard. It should be a question of whether or not he maintains an economic interest or element of control that would require licensure. That's important from a risk management and control perspective for the licensee. I'll give you an analogy. If the general manager of the resort woke up one day and decided that he did not wish to proceed with renewal, he would be fired and replaced by someone who would meet the obligations of his job. Maggie McGurko has that authority to control that risk. Maggie McGurko does not have the ability to fire Mr. Hardy as grantor. That fact that he is a grantor is a historical fact that cannot be changed. He was the grantor for this trust in 2001, and it simply he will never cease to have been the grantor of this trust in 2001. The third interpretation, the one that we respectfully submit to you, is the reasonable interpretation that would be intended by the General Assembly, is that he should remain, he should have come forward once, make sure he's found suitable, and then only remain licensed to the extent that he has an economic interest or element of control that would require licensure. And as the stipulations set forth, in particular, stipulations 35 through 38, Mr. Hardy does not derive any economic benefit or have any element of control of the licensee or the trust that would require licensure. And so for those reasons, we would respectfully submit that he should be, Woodlands Fayette should be permitted to surrender Mr. Hardy's license. And with that, I'll take any questions.
Fine. Counsel?
Thank you. Good morning. Beth Manifesto, Manifesto, on behalf of the Office of Enforcement Counsel. In our opinion, the reason we're here in simple terms is that Mr. Hardy has been licensed as a principal. He is the grantor of the 2001 Irrevocable Trust for Margaret McGurko. This trust, as stated, is the ultimate owner of Woodlands Fayette, LLC, which is the holder of the Category 3 license. Now Mr. Hardy seeks to surrender this license. Under Pennsylvania law, this cannot be done. Pursuant to the Gaming Act, Section 1325D, it clearly states the board shall determine the eligibility of a trust in accordance with the following. No trust shall be eligible to hold any beneficial interest in a licensed entity unless each trustee, each grantor, and each beneficiary, including a minor child beneficiary, qualifies for and is granted a license as a principal. The eligibility of a trust relies in part on the eligibility of its grantors, beneficiaries, and its trustees. The only exception carved out to the requirement of principal licensure is for that of a trustee, which is a banking or lending institution. Quite obviously, Mr. Hardy is neither a trustee, a banking institution, or a lending institution. Pursuant to the Act, a grantor of a trust must initially be found suitable for the privilege of participating in Pennsylvania's gaming industry. It is a basic, common standard in the gaming industry that suitability is ongoing, meaning those licensed must maintain suitability standards under which they were licensed in order to maintain good standing within the gaming industry. Further, under the Act, those licensed must periodically file renewal applications in order to assure these suitability standards have been maintained. Through the renewal process, applicants must again demonstrate their suitability and that there has not been an overall negative impact upon their suitability since he or she was last licensed. These are the basic core responsibilities of gaming regulator and of the gaming industry in what is a very strictly regulated business. These core responsibilities were readily consented to by the petitioner when a Category 3 license was sought. Now that the petitioner has the Category 3 license, these responsibilities are deemed to be a nuisance. The Office of Enforcement Counsel respectfully would request that this board deny the relief that has been requested by the petitioner.
Thank you. Any questions from the board on this matter?
Mr. Chair, I have two. For Enforcement Counsel, I'm trying to recall everything that I read in the various versions of the, because there were amendments to trusts. And is Ms. McGurko the only what am I trying to say? There's an issue of Ms. McGurko. I can't remember if it's one or two children. Are they named in any of those documents as beneficiaries, or is she the only beneficiary? I thought I read that there was a beneficiary issue in the documents.
She is the only beneficiary until her death.
Okay. And for counsel for Woodlands Fayette, As the only beneficiary of this trust, and as you said, someone who has absolute control, for lack of a better way to say it.
That's fine.
I'm not real familiar with trust law, but is there some other mechanism by which, legal mechanism, by which an existing trust like this can be made another kind of a trust that kind of changes the status of who the grantor is?
No, the grantor of this trust will always have been the grantor of this trust. The only other mechanisms would be to transfer the assets to another newly formed trust, if that's where you're going.
And is that legal?
A business entity like the 2001 trust could enter into transaction to transfer assets freely provided that Ms. McGurko approves it, but that would trigger taxable consequences. It would trigger a 1328 change of control. If the ownership of the resort changed, it would be the consequences would be prohibitive simply to change the status of the grantor on
Prohibitive or expensive? Or are you
prohibitively
making them?
prohibitively expensive.
Thank you. I have no further questions.
Any other questions from the board? Yes.
Actually, although it is rare under the Cypre doctrine, you could have a court completely redo a trust. Now, that usually takes a passage of time. But would you agree with that?
My familiarity with the Cypres doctrine would be with respect to the purpose with respect to the trust was granted, i.e., if the trust was formed for the education of the beneficiary, and the trustee thought that that purpose was not feasible any longer, but that the grantor would have supported a slightly different articulated purpose, they could go to the court and get that purpose re-articulated. My understanding is not that the Cypres doctrine could change the historical historical fact as to who was the grantor.
Okay, thank you.
Any other questions at time?
If I may add something, one of the things also about the trust is that although it's an irrevocable trust, it's still, granted certain circumstances have to be met, but it could still revert back to Mr. Hardy.
Under what circumstances?
So,
If, for example, Ms. McGurko passed away and her issue also passed away, there are certain circumstances where the trust could return to Mr. Hardy.
I can theoretically.
I hear you. Tell me how. Like I'm a fifth grader. I don't understand it. So give me the example that could happen.
Well, for
You
example,
said under certain circumstances. So give me
right.
one.
Presently, Ms. McGurko is the beneficiary to the trust. If she was to become deceased, then it would go to her issue. If something happened to her issue and they were no longer there, then I believe the trust lists 2 or 3 options, and one of them is that the trust and the assets return to Mr. Hardy.
If I can put it plainly, if Mr. Hardy at 96 years old outlived his daughter and his grandson, he could re-inherit the beneficial interest.
you both said the same thing.
Yeah.
Okay, if there are no other questions, thank you for appearing today. We're going to take this up a little later this morning. Next, we have consideration of a motion to approve the minutes and transcripts of our October 31st meeting. May I have such a motion, please?
Mr. Chairman, I move that the board approve the minutes and transcript of the October 31, 2018 meeting.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Kevin? Executive Director's Report.
Chairman, members of the board, this morning I would like to update the board on qualified gaming entities within the context of Interactive Gaming Initiative. So as a summary, Act 42 of 2017, the gaming expansion legislation, provided for the implementation of interactive gaming in the Commonwealth of Pennsylvania. 13 interactive gaming certificates were made available in each of the following three categories: peer-to-peer poker, non-peer-to-peer slots, and non-peer-to-peer table games. The 39 interactive gaming certificates were initially made available to the 13 slot machine licensees in the Commonwealth for a period of 120 days. After that time period expired and after the subsequent withdrawal of one applicant, 4 peer-to-peer poker certificates, 3 non-peer-to-peer slot certificates, and 3 non-peer-to-peer table game certificates remained available. Pursuant to the Gaming Act, the board was then authorized to establish procedures to allow for qualified gaming entities to apply for the remaining interactive gaming certificates. The board set out guidelines stating that an entity seeking interactive gaming certificates must file a petition with the required contents between October 15th and October 31st, 2018. The board received 2 petitions for consideration as qualified gaming entities for the issuance of interactive gaming certificates. The first petition was filed by Marina District Development Company, LLC, a subsidiary of MGM Resorts International, the operator of the Borgata Casino in Atlantic City, New Jersey, as well as other casinos throughout the United States. Marina District seeks to offer all 3 forms of interactive gaming. The second petition was filed by Golden Nugget Pennsylvania, Inc., a subsidiary of Golden Nugget, who operates the Golden Nugget Casino in Atlantic City, New Jersey, as well as other casinos throughout the United States. Golden Nugget seeks to offer non-peer-to-peer slots and non-peer-to-peer table games. I have been informed by the Office of Chief Counsel that following its review of each petition and its review of the Office of Enforcement Counsel's responses to those petitions, that it has been determined that all required documentation has been provided by the 2 entities. As such, both petitions have satisfied the requirements for qualified gaming entity status. Each may now proceed to file applications for slot machine operators licenses and undergo the requisite investigative process and be found suitable for licensure by this board. Although it was previously anticipated that a blind random drawing to select from multiple petitioners would be necessary, that is not the case. Marina District and Golden Nugget Pennsylvania, Inc. are both proceeding forward in the process toward approval to offer interactive gaming in Pennsylvania. So that's a summary of where we stand currently with the qualified gaming entities. If you have any questions, I'd be glad to answer.
Just one, Kevin. At this time, in your judgment, would it be appropriate for us to reopen this process in some way?
Well, we're still in the process of getting the 13 casino licensees, those who had applied for interactive gaming. We're still in the process of moving forward to implement that activity. So my recommendation would be that that's certainly an option for the board, but I think it should be considered a little bit further down the road.
Thank you very much. Thanks, Kevin. Danette, Office, excuse me, of Human Resources. Good morning.
Good morning. Good morning, Chairman, board members. The Office of Human Resources has one motion for your consideration today relative to the hiring of one individual. Daniel Cowley has been selected as an investigator for the Western Region under the Bureau of Investigations and Enforcement. He has completed the interview process, background investigation, and drug screening, and is recommended for hire by Director of Investigations and Enforcement, Paul Morrow. Unless you have questions, I ask that the board consider a motion to approve the hiring action as indicated.
Any questions or comments? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the applicant for hire as proposed by the Human Resources Director.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thank you, Danette.
Thank you.
Claire Yantis.
Good morning, Chairman, board members. I'm here today to present the second quarter budget status update for fiscal year 2018-19. The current year budget appropriation is $46,153,000. Overall, we are within budget and currently projecting a surplus due to higher than anticipated vacancy rates. Overall, first half expenses were up $1,235,114, or 6.8%, to $19.4 million. This is primarily due to timing differences in processing invoices for operating expenses and gaming expansion. Personnel expenses were $17.2 million, or 89% of overall agency expenses. This is an increase of 4.4% over last year due to salary and complement increases. The overall benefit rate was 69% of salary expenses, down from 71% for the same period last year. The average employee count for the first half of the year was up 3 to 295 positions from 292. In the operating and fixed asset expenditure categories, expenses totaled $2.2 million, or 11% of agency costs. This is up $508,000, or 30% from the same quarter last year. The increase is primarily the result of timing differences. For the first half of the fiscal year, the largest operating and fixed asset expenses were rentals and leases, which totaled $781,000, or 36% of operating expenses, followed by services, including fees for fingerprints used in background investigation and interagency billings at $690,000, and data and telecommunication expenses at $237,000. Unless you have any questions.
Okay. Any questions or comments from the board on the budget? Thanks a lot, Claire.
Thank you.
Before we proceed to the Office of Chief Counsel, we're going to take a very brief break. A few minutes.
Testing, testing, 1, 2, 3, doing a microphone check, and it's in the room, working. Excellent. And then testing, 1, 2, testing, 1, 2, 3, doing a microphone checks, coming through okay? Good, thank you.
Doug, before we begin, our discussion in the back has indicated that the desire of the board is to table and give further consideration to your petition. We'll take it up at some time in the near future. Okay, so we're just going to table it for now. Thank you.
Good morning, Chairman, members of the board. We have just one petition before you for consideration today. The matter is the Jerome Beninati's request for removal from the board's involuntary exclusion list. The documents in support of this, in relation to the petition, along with OEC's answer and the evidentiary record, have been provided to you in advance of the meeting. By way of background, on August 9th, 2016, Mr. Beninati, who was 20 years old at the time, attempted to enter Mount Airy Casino by providing a false identification. As a result of his actions, the Office of Enforcement Counsel filed a petition requesting he be placed on the board's involuntary exclusion list. Consequently, the board did place him on the exclusion list until at least July 12th, 2018, at which time he could petition to be removed. In December of this past year, Mr. Beninati, through his counsel, filed a request to be removed from the board's exclusion list. There's no objection to that request, and it's ready for the board's consideration.
Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve Jerome Benati's petition for removal from the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next, presenting withdrawals and a report and recommendation is Steve Cook.
Morning. The board has received several unopposed petitions to withdraw the applications or surrender the credentials of the following individuals: Christopher Cody Williamson, Matthew Frank, Franchise Merger Sub Inc., Charles Atwood, Stephen Craig Comer, Ron Huberman, Desiree Catherine Rogers, James L. Martineau, Anthony Sanfilippo, Carlos A. Ruiz Sanchez, Donna S. Negrado, Neil E. Walkoff, Vincent Zahn, Cheryl Condra, Christina Jeanette Donaldson, Jeff Danis, the Carlino Family Trust, Simon Fothergill, John Rowan, and Robert Pickus. The Office of Enforcement Counsel has no objection to any of these withdrawals or surrenders, and as a result, if the board were to grant same, they'd be doing so without prejudice. These matters are all now ripe.
Thank you. Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board issue the orders to approve the withdrawals and surrenders as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter before the board is a report to the board received from the Office of Hearings and Appeals regarding Greenwood Gaming and Entertainment Incorporated's petition to waive Section 465A.19 of the board's regulations, or, in the alternative, to have the board interpret that section as allowing the processing of poker dealer tips at the end of a shift in a very particular way. The board has, in advance of this meeting, been provided with the report issued by Office of Hearings and Appeals, along with the complete evidentiary record in the matter. The case was the subject of a hearing held before the Office of Hearings and Appeals on August 14th, 2018. Briefly, Greenwood is asking to modify its internal controls procedures so as to allow poker dealers who retain their own tips to assist cage cashiers charged with the process of opening the dealer's tip boxes and counting the chips as tips. Specifically, Parks requests the dealers be allowed to rack their chips by denomination for the cashier in an area with surveillance coverage before the cashier counts the tips. Greenwood asks for this change in order to expedite the process at the end of dealer shifts, where dealers at present can wait up to 25 minutes to have their tips counted. The Office of Enforcement Counsel filed an answer objecting to the petition, arguing that the entire process of counting poker dealer chips received as tips must be done by cage personnel, and the dealer cannot assist in that process, and that to allow otherwise could result in dealers pocketing chips before they are counted, thereby hiding income from taxing authorities. As I indicated, the record in this matter is now closed and it is ripe for the board's consideration.
Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board deny Greenwood Gaming and Entertainment, Inc.'s petition for waiver of Section 465A.19 of the Pennsylvania Gaming Control Board's regulations as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter before the board is a report and recommendation pertaining to Jessica Benning. In April of 2018, Ms. Benning submitted an application for a non-gaming employee registration seeking employment as a cashier host at the Meadows Casino. On June 4th, 2018, the Office of Enforcement Counsel issued a notice of recommendation of denial of Ms. Benning's application based upon her failure to fully disclose her criminal history, failure to cooperate with the board, and delinquencies of over $14,000 in fines and costs related to her criminal convictions. Specifically, between 2008 and 2017, Ms. Benning had been arrested and convicted of numerous offenses, including driving under the influence, public drunkenness, various drug charges, retail theft, trespassing, and traffic violations. A hearing in this matter was held September 11, 2018. Ms. Benning did not attend that hearing. As a result, OEC put in evidence of the convictions and her failure to fully report the convictions. As a result of that, the report and recommendation issued recommends that Ms. Benning's non-gaming employee registration application be denied.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding Jessica Benning's application for non-gaming employees registration, as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next report and recommendation before the board today pertains to Nicholas Anderson's request to be removed from the board's involuntary exclusion list. On May 17, 2017, the board placed Mr. Anderson on the list after he was arrested and charged with harassment, disorderly conduct, and defiant trespass following an incident at the Rivers Casino. Specifically, in January of 2017, while visiting that casino, Mr. Anderson, along with two other individuals, were asked to leave and were escorted to the main lobby of the facility due to their level of intoxication. Mr. Anderson at that time attempted to run and hide. He was once again found on the gaming floor, again escorted to the main lobby where he became belligerent with security personnel and, in fact, placed his hands on one of the security officers. On April 9, 2018, Mr. Anderson filed his request to be removed from the exclusion list. A hearing in this matter was held in September of 2018. The Office of Enforcement Counsel and Mr. Anderson both attended the hearing and put evidence into the record. Mr. Anderson does not dispute the underlying allegations and was apologetic about his behavior. He also testified that he was actually found not guilty of the criminal charges he was originally charged with, and that he has greatly matured since this incident. The board regulations generally require an individual to wait 5 years to seek removal from the excluded persons list, absent extreme circumstances, and the hearing officer ultimately found that although Mr. Anderson did appear remorseful for this situation, he did not show extraordinary or extreme facts or circumstances which would support an early removal from the list, and that is the recommendation.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopts the report and recommendation issued by the Office of Hearing and Appeals regarding Nicholas Anderson's petition for removal from the PGCB involuntary exclusion list described by the Office of Chief Counsel, and that Mr. Anderson remains on the list.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter pertains to a request for removal from the self-exclusion list. In January of 2018, an individual with the initials TS filed a petition for removal from the self-exclusion list. The Office of Enforcement Counsel filed an answer objecting to that petition. A hearing in this matter was held on September 27, 2018. OEC attended the hearing and put evidence into the record. TS failed to attend the hearing. Pursuant to the findings of fact in the report and recommendation, TS on July 21, 2017 entered the Sands Casino Bethlehem and met with the casino compliance representative regarding the self-exclusion. The CCR testified that he conducted the mandatory interview of TS and completed all required paperwork and procedures. As a result of that evidence, TS at that point in time actually signed up for a 5-year period of self-exclusion. As a result of hearing that evidence, the report and recommendation issued subsequent to the hearing recommends that TS not be removed from the list as 5 years have not run, and therefore he is not eligible for removal.
Questions or comments from the board? Have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding TS's petition for removal from the voluntary self-exclusion list as described by the Office of Chief Counsel, and that TS remain on the board's voluntary self-exclusion list.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next report and recommendation before the board today pertains to Timothy Nugent. Mr. Nugent's gaming employee occupation permit was renewed in June of 2016, and he worked as a table games dealer at the Mohegan Sun Pocono Casino. On May 3rd, 2018, the Office of Enforcement Counsel filed a complaint to revoke Mr. Nugent's gaming employee occupation permit after alleging that on November 16th, 2017, he stole a $100 chip from the float at a table he was working. A hearing in this matter was held on August 23, 2018. The Office of Enforcement Counsel, as well as Mr. Nugent and his attorney, appeared at the hearing. Mr. Nugent did not testify. At that hearing, OEC offered testimony and documentary evidence, including video evidence. The video evidence presented by OEC shows that on November 16th, Mr. Nugent took a $100 chip from the float while replenishing the chips during the closing process of the table game he was working. He thereafter placed the chip in his left hand, moved his hand below the table, and then returned his left hand to the table without the chip. On November 17th, the table was reopened by another dealer who found a plastic glamour in place of the chip, and then subsequently on November 18th, 2017, during the closing of the table, the $100 discrepancy was discovered and reported. During the hearing, Mr. Nugent's counsel argued that the $100 chip was reported missing 2 days after his client's shift ended, and since other dealers had access to the table during that period of time, one of them could have been responsible for the theft. The hearing officer, however, having witnessed the video evidence, sided with OEC and ultimately recommends to the board that Mr. Nugent's gaming employee occupation permit be revoked.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board adopt the report and recommendation issued by the Office of Hearing and Appeals regarding the revocation of Tim Nugent's gaming employee occupation permit as described by the Office of Chief Counsel.
Second.
All in favor? Aye. All opposed? Motion's adopted.
The final report and recommendation before the board today pertains to Derek Paris. Mr. Paris was issued a non-gaming employee registration and was employed as an EVS attendant at the Parks Casino. On September 17, 2018, the Office of Enforcement Counsel filed a request for an emergency suspension of Mr. Paris's non-gaming employee registration after receiving notice that he had been charged with numerous criminal offenses relating to child pornography and sexual abuse of a minor. As a result of these charges, the board's executive director issued an emergency suspension suspending Mr. Paris's non-gaming registration. A hearing in this matter was held on October 10, 2018. The Office of Enforcement Counsel appeared at the hearing, putting into evidence the charges and the nature of the charges faced by Mr. Paris. Mr. Paris did not attend that hearing, nor did he request a continuance. After hearing all of the evidence presented, the report and recommendation issued by the hearing officer recommends that the suspension remain in place, and that is the recommendation before the board.
Questions, comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the suspension of Derek Paris's non-gaming employee registration as described by the Office of Chief Counsel.
Second.
All in favor? Aye. All opposed? The motion's adopted.
That concludes the matters of the office.
Thank you, Doug. Sue Hensel, Bureau of Licensing. Welcome.
Thank you, Chairman Barish and members of the board. Before the board today will be a change of control and the related licensure for a Category 1 slot machine operator, one interactive gaming manufacturer, and one VGT procurement agent. In addition, there will be 780 principals as well as key gaming and non-gaming employee applicants. In addition, there will be the consideration of 4 gaming service provider applicants. The first matter for your consideration is the licensure of PID LLC, which is a wholly owned subsidiary of Churchill Downs Incorporated, through which Churchill Downs will operate Presque Isle Downs and Casino. On August 15, 2018, the board preliminarily approved the change of control of Presque Isle Downs from Eldorado Resorts, Inc. to PID LLC, subject to certain conditions, including the licensure of PID LLC and its principals. PID LLC has filed applications for all required individuals and entities associated with the transaction. The Bureau of Investigations and Enforcement has completed its investigation of the applicant, and the Bureau of Licensing has provided you with the background investigation and suitability report. I have provided you with a draft order and ask that the board consider approving the change of control and the licensure of PID LLC and its principals.
Enforcement Council has no objection.
Thank you. Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve for licensure parties related to the change of control of Category 1 slot machine licensee El Dorado Resorts, Inc. to Churchill Downs Incorporated, operating Press Isle Downs and Casino through PID LLC as described by the Bureau of Licensing. I further move that the board approve the change of control with the conditions requested by the Bureau of Licensing and Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next for your consideration is a conditional interactive gaming manufacturer license for Majim Services OU. Majim Services OU is a software development company that provides services for Rush Street Interactive Development, LLC. Majim Services OU is an Estonia-based company that plans to offer interactive-related gaming products and services in the Commonwealth. Under the board's temporary regulations, an interactive manufacturer applicant is eligible for conditional licensure if the applicant has submitted a complete licensing application and fees, and the Bureau of Licensing and the Bureau of Investigations and Enforcement does not object to the issuance of the conditional license. Majim Services OU satisfies these criteria. I provided the board with a draft order and ask that the board consider the order to approve Majim Services OU for conditional licensure.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant Majim Services OU's conditional interactive gaming manufacturer license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
In addition, there is a conditional license for the VGT procurement agent applicant, Commonwealth America LLC. Commonwealth America LLC is a Hinsdale, Illinois-based entity. A procurement agent negotiates terminal placement agreements on behalf of a VGT terminal operator for placement of VGTs in truck stop establishments. In order to be eligible for conditional licensure, the procurement agent applicant must meet certain criteria, including filing a completed application, having never had a similar license denied or revoked, having never been convicted of a felony or gaming law violation, and being current on state taxes. The Bureau of Investigations and Enforcement has conducted a preliminary review of the applicant, and I have provided you with a conditional licensure report. I have provided you with a draft order and ask that you consider the order to approve a conditional license for Commonwealth America LLC.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grants Commonwealth America LLC video gaming terminal procurement agent license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
In addition, there are principals and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with a proposed order for 2 principals and 4 key employees. I ask that the board consider the order approving these licenses.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the principal and key employee licenses as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
There are also temporary principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 2 principals and 7 key employees. I ask that the board consider the order approving these licenses.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board grant the temporary principal and key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 583 individuals to whom the Bureau has granted temporary or full occupation permits, and 166 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the board consider a motion approving the order.
Enforcement Council has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the gaming employee occupation permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
There is also a recommendation of denial for gaming employee applicant Dustin Atkinson. The applicant was notified that he was being recommended for denial and failed to request a hearing within the specified time frame. The Bureau of Licensing has provided you with an order addressing Dustin Atkinson, who the Office of Enforcement Counsel has recommended for denial. I ask that the board consider an order approving the denial.
Enforcement Counsel continues to request denial in this matter.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board deny the gaming employee occupation permit application of Dustin Atkinson as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Also for your consideration are withdrawal requests for gaming employees. In each case, the permit is no longer required. For today's meeting, I have provided the board with a list of 8 gaming employees. I ask that the board consider the order approving the list of withdrawals.
Enforcement Counsel has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board grant the withdrawal of gaming and non-gaming employee applications
Second.
as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next, we have an order to certify Center Stage Entertainment, Inc. I ask that the board consider the order approving this gaming service provider for certification.
Enforcement Counsel has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the application for Central State Entertainment, Inc. gaming service. I'm going to start that over again.
Start again.
Mr. Chairman, I move that the board approves the applicant for Center Stage Entertainment, Inc. for gaming service provider certification as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Finally, for your consideration are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 3 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Counsel has no objection.
Questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider registration as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
Aye.
Opposed? The motion's adopted.
That concludes the matters of the Bureau of Licensing.
Thank you, Sue.
The Office of Enforcement Counsel will present one matter for today for the board's consideration, in which we will request the board's approval of one revocation. That matter will be presented by Assistant Enforcement Counsel Ashley Gabriel.
Good morning, Mr. Chairman and members of the board. Ashley Gabriel, Gabrielle, Assistant Enforcement Counsel with the Office of Enforcement Counsel. Next on the agenda for the board's consideration is a complaint seeking the revocation of the non-gaming employee registration issued to Sean Simons. The complaint has been filed with the board's Office of Hearings and Appeals and properly served upon Sean Simons. Sean Simons failed to respond within 30 days as required by board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment and properly served the same upon Mr. Simons. Therefore, the facts in the complaint are deemed admitted. All filed documents have been provided to the board, and the matter is presently ripe for board consideration. On July 24, 2018, Mr. Simons pled guilty to endangering welfare of children, parent, guardian, or other commits offense, which is a third-degree felony, and indecent assault on a person less than 13 years of age, which is also a third-degree felony. Mr. Simons is not currently employed by the Pennsylvania gaming industry. At this time, the Office of Enforcement Counsel requests that the board revoke the non-gaming employee registration issued to Sean Simons.
Any questions or comments from the board? Hearing none, may I have a motion?
Mr. Chairman, I move the board approve the revocation of Sean F. Simons' non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor? Aye. All opposed? The motion's adopted.
Thank you. That concludes our business.
Thank you very much. Okay, that concludes today's public meeting. The next public meeting will be held on Wednesday, February 6th at 10 a.m. in this room. May I have a motion to adjourn?
Second.
All in favor?
Aye.
All opposed? We are adjourned. Thank you.